Good morning, everybody, and welcome to Law and Society. Today, we are going to have a continuing discussion of the disqualification clause under the 14th Amendment's Section 3. I have talked about it many times before, and I bring it up again today because I told you that I was going to break down the latest law review article that was written by two conservative professors of law in very respectable law schools across the country, Professor William Baude and Professor Michael Stokes Paulsen. And these two professors are active members of the Federalist Society, which is an extremely conservative group of people who wield an enormous amount of influence in legislative and judicial circles. So the basic crux of uh, the disqualification clause is quite simple, really. So the reason why I bring it up today is because first of all, I had intended to start talking more about this article because it is so profoundly written. I believe that it should be looked at. And then I wanted to wait for the right time to do it. And lo and behold, yesterday I received a barrage of comments by this one individual on YouTube who talked about the Constitution annotated website of the government that gives you an encyclopedic understanding of what any sort of legal issue or constitutional issue is. So here, when there's an overview of the disqualification clause of Section 3 of the 14th Amendment. And so it gave a description, and this individual, uh, doubled down and called my work to be misinformation. And so I found today to be the perfect time to dive back into the very well written law review article that I will be reading to you today. It's called The Sweep and Force of Section 3, and it's by Professors William Baude and Michael Stokes Paulsen. It is forthcoming in the upcoming University of Pennsylvania Law Review, and you can get the electronic copy of it at a link that I've provided in the description box of this video. You can also find a link of Article 5 of the Constitution, because that's what I will be starting out talking about as we go into this disqualification conversation. I may not be looking at any questions at the moment, and once I am done with this analysis, I will take questions. So if you have any questions, please, you can leave them in the comment box or you can leave them in the chat and I will get back to you. So if you're new, please like and subscribe and share, and let's dive in. The disqualification clause, the argument that has been made that congressional statutes can overrule the constitutional amendment, Section 3 of the 14th Amendment, is a ludicrous idea, because the Constitution itself spells out in Article 5 what is needed for there to be an amendment to the Constitution. And an amendment that has been ratified and put into the Constitution is part of the Constitution. We only have in our history one instance of that happening, and that was with the 18th Amendment, which was prohibition of alcohol. And then that was repealed in 1933 by the 21st Amendment. And it just so happens it fell on my birthday 90 or 89 years ago, 91, something. December 5th of 1933 is when the 21st Amendment repealed the 18th Amendment. My point is to say that under Article 5 of the Constitution, Congress by statute does not have the power to just unilaterally change Section 3 of the 14th Amendment. If you want to change the amendment, 14th Amendment, you have to do so by the rules of Article 5 of the Constitution itself. So that is one way of looking at the argument, and that's not what I'm going to be reading to you from the law review article today. That is me telling you that there's this argument that the act there were congressional acts in 1872 and then 26 years later that removed disabilities that were incurred. So it's talking about this. So what I'm going to do now is I'm going to read you the Section 3 of the 14th Amendment. And after I read you that, I will read you the encyclopedic information that is part of the Constitution.gov website. Here we go. No person shall be a senator or representative in Congress or elector of president and vice president or hold any office, civil or military, under the United States or under any state who, having previously taken an oath as a member of Congress or as an officer of the United States or as a member of any state legislature or as an executive or judicial officer of any state, to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof, meaning Constitution of the United States. The second sentence of Section 3 of the 14th Amendment says, but Congress may, by vote of 2/3 of each house, remove such a disability. So what that says is that when somebody has engaged in insurrection or rebellion against the Constitution of the United States or provided aid and comfort to somebody who has engaged in insurrection or rebellion against the not against the United States, against the Constitution of the United States, that person is disqualified, and Congress has the retroactive power of, or should I say, retrospective power of curing that disability by removing that disability by 2/3 vote of Congress. There's no constitutional amendment in the history books or in constitution.gov that says anything about the rescinding or the ending of Section 3 of the 14th Amendment. Quite to the contrary. Drink of water. So now I will read you the encyclopedia information that is provided in that website. The right to remove disabilities imposed by this section was exercised by Congress at different times on behalf of enumerated individuals. The right to remove disabilities. So at the get-go, there is no conflict as to the application of Section 3. It happens when somebody engages in insurrection and or rebellion against the Constitution. This encyclopedia information talks about the two instances where there was a congressional act by 2/3 of Congress to remove the disability that was imposed on people who at that time in 1872 and then 26 years later enacted or violated Section 3 and was therefore disqualified. They were requalified, so to speak, by Congress's act. There is no, in the information provided on that website, there isn't anything else that talks about Congress's power to take away the power of Section 3 of the 14th Amendment. It simply doesn't have that, because you cannot change the Constitution without a constitutional amendment. So if you are to change the 14th Amendment, you got to have another amendment that requires 2/3 of both the chambers of Congress, and then 3/4 of the states' legislatures to be able to be ratified into the Constitution. So the threshold is much, much, much higher for Congress, because Congress cannot alone do anything to Section 3 of the 14th Amendment. So now, putting aside what that individual brought up and called my work or my information to you disinformation, I want to go to the article that I talked about by Professor Baude and Professor Paulsen. And before I do that, I want to give you an idea that, there are many types of speech we engage in. We engage in political speech, we engage in legal speech, we engage in just a social speech. And the answer to whether the 14th Amendment Section 3 should apply as a matter of politics, as a matter of law, and as a matter of social implications are very different. And the answers of whether to apply this will come out differently, whether you're looking at it politically, whether you're looking at it from a social perspective, or if you're looking at it from a constitutional legal perspective. What I provide is an understanding of the Constitution and constitutional provisions as crafted by the framers and then subsequent people who ratified subsequent amendments, and then inform you about further scholarship on the matter. So Professors Lawrence Tribe and Judge Michael Luddig published an article about the 14th Amendment where they went into it in good detail, but it wasn't by any means as much in depth as this article, this law review article. So I will read you sections of it. Today I will start with the introduction part, and time willing, I will go on to section 1 of the article. But it's a very long article. But I believe that this, from a constitutional and legal point, needs to be understood, and from a historical perspective. Because as we have seen politicians talk about on media, the political implications of bringing this 14th Amendment's disqualification clause are not good. But the constitutional imperative is high, and the risk of eroding the foundations of democracy is higher if this disqualification clause isn't applied as it was applied in 1872. And then if both houses of Congress remove that disability, fine. Then Donald Trump can run again. But Donald Trump has to go through that process. And this article really breaks down the historical, legal, and constitutional analyses, not so much the political or social, because this is a law review article, and my channel is about law and society. So I'm a bridge that is bringing an understanding that I have gathered from reading materials and from publicly available news. This article is publicly available now on the website that I provided in the description of this video. It is a constitutional, historical, and political question. So let's start out with this, the beginning of this, the introduction. This section of the 14th Amendment was designed to address a particular historical situation and acute problem arising in the aftermath of the Civil War. States in the South had purported unconstitutionally to secede from the Union. They had purported to form the so-called Confederate States of America in rebellion against the authority of the US Constitution. And they had waged a bloody 4-year war of rebellion against the United States. Yet, even after the rebellion had been defeated, Southern states had audaciously sent to Congress to serve as US senators and representatives men who had notoriously violated previously sworn oaths to support the US Constitution by subsequently engaging in or supporting in secession, rebellion, and civil war against the authority of the United States. To say nothing of those now serving in their state, again, in their state governments. These men who arrived in Washington included several who had held prominent positions in the rebel Confederacy, 4 Confederate generals, 4 colonels, several Confederate congressmen and members of Confederate state legislatures, and even the vice president of the Confederacy, Alexander Stephens. So that is the historical context. And then you fast forward a century and a half, and we get to the events of the presidential election. The events surrounding efforts to overturn the election of the presidential election of 2020 have sparked renewed scholarly, judicial, and political interest in Section 3 of the 14th Amendment. And as I've said, the political implications are not the best. The core events are familiar to all: the dishonest attempts to set aside valid state election results with false claims of voter fraud, the attempted subversion of the constitutional processes of state selection of electors for president and vice president, the efforts to have the vice president unconstitutionally claim a power to refuse to count electoral votes certified and submitted by several states, the efforts of members of Congress to assert a similar power to reject votes lawfully cast by electors, the fomenting and immediate incitement of a mob to attempt to forcibly prevent Congress's and the vice president's counting of such lawfully cast votes, all in an attempt to prevent the defeated incumbent president, Donald Trump, from losing power in accordance with the Constitution. So, as we see, these Federalist Society professors are saying this. This is not a Democrat, radical Democratic base talking about it. You know, Judge Michael Luddick, who agrees with progressive professor of law Lawrence Tribe, Michael Luddick was a part of the one of the counsels for Reagan, and then he is a legal giant in the conservative movement, in conservative ideology, and in the conservative ideology, the application of Section 3 couldn't get any clearer. This was, going back to the article, this was undoubtedly a serious assault on the American constitutional order. As legal officials and citizens generally have begun to confront the application of Section 3, they have foundered on the most fundamental questions. How does Section 3's disqualification apply? Does it apply to those who planned, supported, encouraged, assisted, incited, or otherwise participated in the events surrounding the attempted overturning of the presidential election of 2020? Does it require implementing legislation or criminal trials or impeachments before its disqualification kicks in? And if Section 3 does apply, to what and to whom? What actions count as having engaged in insurrection or rebellion against the Constitution of the United States, or having given aid or comfort to enemies thereof? Which officials are covered by Section 3's inclusions? These are the answers that we're going to get in this article. First, then continuing in the introduction, first, Section 3 remains legally operative. It is not a dead letter. Section 3 is prospective. Congressional amnesty is retrospective. And as I said in the beginning in my introduction, that the disqualification clause applies and it has to be enforced by authorities. And we have seen already certain people take action in courts to enforce the disqualification clause in Colorado. Now, there's an issue with rightness and standing. Rightness meaning, is the case ready to be heard? Standing meaning, do the people who have brought this case have the right to bring this case? I think both those questions are, I don't know. We'll have to see what the judge says. But I know the parties who would be harmed, and that would be the people who are current candidates running against Donald Trump in the Republican primary. They, each of them, by the way, have standing, because Donald Trump, by being part of that group, is changing the entire dynamic of the Republican Party's nominee structure. And it is doing them harm by not, and doing the Republic harm by not talking about the issues, not bringing up the other people who are viable candidates for president. Donald Trump is not, at least not until he goes through the congressional amnesty, which is retrospective and would apply after he has been disqualified. And that is by 2/3 vote of both houses of Congress. Second, Section 3 is legally self-executing. It follows that Section 3's disqualification may and should be followed and carried out by all those whose duties are affected by it, which means pretty much anybody who is in charge of the election ballots in the various states. But no prior judicial decision and no implementing legislation is required for Section 3 to be carried out by officials sworn to uphold the Constitution, whose duties present the occasion for applying Section 3's commands. While Section 3's requirements could be made the subject of enforcement legislation by Congress, no such legislation is constitutionally required as a prerequisite to Section 3 doing what Section 3 itself does. So there is, and one of the inferences, now I will draw away from this article, and I will say one of the ways that at least I was taught to look at the Constitution is when you read clauses, when you read portions of the Constitution, don't just think of what it says, think of what it also doesn't say. And if you look at Section 3 of the 14th Amendment, it starts out by saying who is disqualified and explaining when they engage in insurrection, not when they're convicted of insurrection, when they participate. Engaged means participate, but it says engaged in insurrection or rebellion. Now, that is the beginning of Section 3. The framers of Section 3 put the second part afterwards, meaning that the constitutional provision of disqualifying somebody who engages in insurrection against the Constitution of the United States is first disqualification and then removal of that disability by two-thirds vote of both houses of Congress. Okay, so the putting it before congressional power to remove the disability puts Section 3's first sentence before, as it pre-applies to the second sentence, which is curing the disability. The first sentence applies. Going back to the article. Third, Section 3 supersedes earlier enacted constitutional provisions to the extent of any supposed conflict between them. Section 3 of the 14th Amendment constitutionally supersedes any prior provision conflicting with its terms. Section 3 supersedes the First Amendment to the extent of any true conflict. To be sure, the proper construction of Section 3's term, insurrection, rebellion, aid and comfort, enemies, will leave much speech and advocacy completely free, which means that is what will be adjudicated. That is what will be talked about. You know, what qualifies as insurrection, rebellion, providing aid and comfort, and enemies. So we will see that in this article. And the last section of this article says that, fourth, Section 3, sorry, let me restart. This leads to the article's fourth and final group of points. Fourth, Section 3's disqualification is sweeping in its terms. It disqualifies from future office-holding persons who engaged in an expansive and encompassing term connoting many forms of participation in or active support of a broad swath of activity covered by the terms insurrection or rebellion, or giving of aid or comfort to enemies of the nation or its constitutional order. It applies to a broad swath of civilian, military, and legislative office holders who swore oaths of fidelity to the Constitution, and it disqualifies such persons from holding in the future any of an extraordinarily broad swath of public offices. Taking Section 3 seriously on its own terms means taking seriously the enormous sweep of the disqualification it creates. And then the article goes into each of the four sections. So I will now stop for a moment and hello, hi, Martine, Art Garden. Thank you for being here. So I'm taking a quick break to see if you have any questions. Why do you suppose the Fourth Amendment just came up? Well, because there has never been an issue before with incumbent president inciting an insurrection and engaging in that sort of a behavior. And removing people from Congress, it has to be done on the ballot level. You know, Nancy Pelosi has done a lot, and her impeachment of Donald Trump twice sends a message. But I remember thinking that Nancy Pelosi was going to sack Marge and other members for yes, but the constitutional method of applying the enforcement could have been congressional, but the presumption then would have been that it had to be 2/3 vote of Congress, because that is the level that is required for removing that disability. So the Speaker Pelosi at the time had to think whether there were votes for 2/3 of Congress to enact legislation to enforce that. But the state of Georgia can stop Marjorie Taylor Greene if she is shown to have engaged in insurrection or provided aid and comfort. And that timing of that is very important, right? Excuse me, let me just. You cannot bring so in 2022 they didn't disqualify because there was nothing to go on other than what we all know, other than everything, other than really everything, because everything is, I mean, a lot of it is out in the open. The January 6th report did a lot. We saw the insurrection with our own eyes, and we continue to see the fallout from it to this day, 2.5 years later. And but the states authorities did not talk about disqualification of them because there had not been any sort of movement anywhere to show that they had engaged in insurrection. January 6th committee did that to a certain point. I believe Jack Smith's indictments are having the impact of showing that they did engage, because indicting somebody, you have to cross the threshold of probable cause and preponderance of the evidence. And you are the threshold between preponderance of the evidence and beyond a reasonable doubt, which the jury will find after they've been given the facts. Now, going to this constitutional provision, the enactment of that has to be based on each of the authorities who have the power to include people in election ballots or not. And so no one has so far invoked, because none of the secretaries of state have invoked that power to bar people. And I believe that is because there hasn't been a showing of due process, that they were at least given the due process of proving that they did not engage in insurrection. And we are now in the process of, we are now in a bifurcated process where we have this Jack Smith prosecutions happening, and then this constitutional remedy that can be applied by state authorities who have power, who have qualifications to judge who gets in the ballot or not. So now I'm going to, I'm at 32 minutes here. If you are still engaged, thank you very much for being here. Please subscribe, and if you like the content, like and share. Art Garden and Food Expressions, you asked the question, why isn't he in jail awaiting trial? Because he paid the $20,000 bond of the $200,000 bond in Georgia. And he wasn't, I mean, he should be. Any other, and many scholars, including Glenn Kirshner and many scholars, have said it's bewildering why somebody who is 4 times criminally indicted is still not in some sort of confinement, and there has been no guardrails put on his use of incitement in social media, incitement of lawlessness. And it is, and prosecutors have brought this up, but judges have been very, very restrained in going after what Donald Trump says, simply because of free speech implications, and also because he started his campaign, so he's going to politicize it. He's already politicizing it. But the question is, when is enough enough? When do the states come out? And yeah, Arizona is looking into it, Martine, and so is Colorado and a handful of other states. And I believe that where there is evidence in those states investigation that there was incitement of insurrection or rebellion or providing aid and comfort, then those jurisdictions, based on their findings by their authorities, not by federal authority, not by Congress's authority, but by that state's authority, keep Donald Trump off the ballot, or not just Donald Trump, anybody else who qualifies in having provided aid and comfort to insurrection or engaged in insurrection. So I'm going to go back and I'm going to go over the first section, which the first section says Section 3 is legally operative today. There are two subsections to that. A, the generality and presumptive perpetuity of constitutional language. And B, has Congress removed the disability for everyone for all time? And could it do so if it wanted to? The answer is no, and I've told you that, but what I'm going to do now is I'm going to read. This is a really, really amazing article because it, you will find the link to this article in the description box of this video. I would implore you to download it because it is free to download and read it. It's a long read and I'm doing it by piecemeal, but today just seemed to be the right day for me to talk about it. So let's go back to it. Section 3 is legally operative today. The generality and presumptive perpetuity of constitutional language. Section 3 was prompted by historical circumstances, but that does not in any way detract from its enduring force. It is, for one thing, a radical rule. Its operation was hugely disruptive to antebellum patterns of elite political leadership, and apparently indifferent to inconvenience and seemingly rather punitive in its consequences. If its disqualification had radical policy consequences for the South, so be it. Section 3 is very much a creation and creature of its day. However, constitutional provisions written into our foundational law live beyond the circumstances that prompted their adoption. And many such constitutional provisions are written in broad or general terms that obviously extend beyond the specific situation or situations that led to their enactment. Sometimes this is by design. The text drafters wrote a general rule applicable to a broad class of circumstances, and a more general, neutral way of addressing a class of situations which the specific problem motivating the writing of the text might be just one instance. And sometimes a text's breadth and generality might not reflect conscious design. The text drafters wrote a general rule that unintentionally went further than the problem they had in mind. Put colloquially, the text sometimes overshoots its drafters' intended purposes. A text might undershoot the problem its framers had in mind to address too, or achieve only part of its intended purpose, perhaps because of political compromise. The reason really does not matter. If the meaning of the 14th Amendment's terms forbade racially discriminatory classifications of any and all kinds as a matter of rules of the late 1860s language and usage, it does not matter one way or another whether it was intended or expected that governments could enforce certain types of racial discrimination, like enforced racial segregation. The rule as adopted might overshoot the purposes, expectations, or desires of those who voted for it. But the rule is the rule. The text's meaning is the text's meaning. Thus, if the framers and the ratifiers of the 14th Amendment enacted a general rule in Section 3, a disqualification from future office holding, heed to having taken an oath to the Constitution and subsequently engaging in insurrection or rebellion against the United States, rather than a provision that by its terms applied only to the case of former Civil War secessionists and Confederate officials and officers, it is the general rule that matters. but the text means what it says. We take it as almost too obvious to require stating that constitutional provisions have indefinite life unless and until repealed or amended by subsequent constitutional enactments. The fact that an unrepealed, unamended provision of law is old does not in any way weaken its legal force. Section 3 remains constitutionally full in force, as alive as the day it was enacted. So that was quite verbose understanding that, at the end, they tell you exactly why, and I talked about it in the beginning. It is that Article 5 of the Constitution tells you how a constitutional amendment is drafted and ratified. But for that, Congress doesn't have a right to just say, okay, we're going to get rid of this part of the Constitution, because the 14th Amendment, Section 3 is part of the Constitution. It has been ratified by 3/4 of the states after being proposed by 2/3 of both houses of Congress, as required by Article 5. Going back to the article. Finally, we take it as almost too, oh wait, I just read that. Sorry. Okay. Subsection B. Has Congress removed the disability for everyone of all time? No. It is wrong on both statutory and constitutional grounds. The key words are imposed and hereby removed. The words of the 1872 statute, and now this is going to the question that was raised by the gentleman who called my work disinformation or misinformation. The statute removed disqualification imposed in italics by the 14th Amendment. That is, disabilities that had already become legally effective. Moreover, the Fourth Circuit continued. The operative clause's principal verb, removed, reinforces its conclusion. In the mid-19th century, as today, that word generally connoted taking away something that already exists rather than forestalling something yet to come. With all due respect, the district court appears, and so this is talking about when those acts were, congressional acts of removal were done. And this is in one of the cases, with due respect to the district court appears to have simply hoodwinked by the feel of all persons whomsoever language and completely missed the other language that made clear the statute's past tense. So there are, this is talking about a case in which the 14th Amendment came up. And then there was the 1898 statute 26 years later. This one removed the disqualification for everybody without exception. Its language is even more laconic. Be it enacted by Senate and House of Representatives of the United States of America in Congress assembled, that the disability imposed, past tense, by the Section 3 of the 14th Amendment of the Constitution of the United States, heretofore incurred, is hereby removed, past tense. The disability imposed by Section 3 is hereby removed. Period. No exceptions. But here, it is also even clearer in the 1898 Act, is backward looking. Like in 1872 Act, the 1898 Act uses past tense language. Heretofore incurred. That is unmistakably backward looking, past occurrence language. There's no reason why framers of the 14th Amendment could not have similarly drafted Section 3 to provide for the provision's own extinction after a supermajority vote of Congress. But that is simply not what Section 3 says. The second sentence of Section 3 is not a grant of power to explode or amend the content of the rule stated in the Section 3. It is a grant of power to remove the consequences of the rule's operation. The second sentence gives, the but sentence, gives Congress the power to remove such disability. The but sentence explicitly cross-references the first. Thus, the most natural reading of the two sentences in relation to each other is that the second sentence confers an exceptions power that only comes into existence when the conditions specified in the first sentence have occurred. And to belabor the point a moment further, the word remove means to displace or to take away something that already exists. This confirms that Congress's removal power, therefore, only comes into being when a legal disqualification has vested by virtue of the operation of Section 3's first sentence. And this is going to be the last part that I will read, and then I will take more questions if you have any. Section 3's first sentence is written as a general and prospective rule, not limited to the specific instance of the Civil War. Section 3's second sentence is written as a continuing power that to grant relief from disabilities already imposed by the operation of the first sentence. The power to remove an extant legal disability is not a power to rescind the legal rule that creates that disability. Thus, not only has Congress never purported to sunset Section 3, it lacks the power to do so by Section 3's own terms. So I see that you all have stuck around. If you have any questions, now would be so I will stop there because that is the end of Section 1. I will read and I will go over Section 2, 3, and 4 in the coming days and weeks when I find the timing to be appropriate. Today's timing was appropriate simply because somebody came onto my channel and claimed that I was spreading misinformation. I have provided the links to this law review article and Article 5 of the Constitution that talks about how constitutional amendments may be amended. And you may go and read those. And so let me go and see this discussion. And I think that Martine and Art Garden and Food Expressions, both of you have kept a good conversation going. I really appreciate that. Yeah, Martine, Chris Christie could very well do that. You know, Chris Christie is somebody who would have standing because he is one of the candidates, viable candidates, whose time is being taken and whose work is being harmed, let alone the Republic's, when Donald Trump is one of the presumptive nominees. So he has standing. So isn't Trump, okay, so thank you. It has been determined firmly. It has been determined many times over in many places that it was an insurrection. It just has to be determined by the authorities who have the authority to put people on election ballots, which is secretaries of state of each of the states. Hello, Deb. Thank you. Good morning. Thank you for being here. Has it been determined firmly and legally? It has. So it is in the process of. It is in the process of being molded into. So when the proof of whether it is an insurrection happens or not, it would be a fact-finding court. It would happen in a district court, and it would happen in a situation where, say, the Secretary of State would refuse to put Donald Trump on their state's ballot. Donald Trump would sue to say that, you know, this is infringing on my right to get on the ballot. And then the Secretary of State would have the burden of proof to prove that he engaged in insurrection or provided aid and comfort to enemies of the Constitution. Now, remember, it says engaged. And as we heard in this article, Professors Baude and Paulsen write about the broad application of the word engaged. It's not convicted. It's not even indicted. So what is the burden of proof of engaged? And we will talk about that in the coming sections. I don't see any more questions. I truly appreciate every single one of you who's here. Please share this article and this episode, as well as the previous one about the general overview of the disqualification clause. I welcome critiques, I welcome questions, and I take the information I provide to you very seriously. It is my responsibility to ensure that I provide you with accurate information. And today seemed to be the perfect day to reassert that, instead of me succumbing to this idea that I provided misinformation. No, the information, sir, that you have provided just wasn't up to date. You are just not up to date with today's scholarship today's legal scholarship on the status of the disqualification clause and the fact that Donald Trump is disqualified from running for elected office for having engaged in insurrection and for having provided aid and comfort to enemies of the Constitution of the United States. So, no, it's not moot, really. Moot would mean that the case has been adjudicated and the issue has been resolved. The issue has not been resolved. So the ripeness is when a case is ready, and mootness is when a case has passed readiness, meaning it has been adjudicated, it has been decided, or the circumstance that gave rise to it no longer exists. That's not the case with the 14th Amendment. The 14th Amendment's disqualification clause has yet to be enforced, which means any case that would come up about disqualification, there's a better argument for the case has not ripened, as opposed to the case having been moot. You see, the mootness comes after, when the substance of the matter or the law addressing the substance of the matter has already occurred. So there's no need for the 14th Amendment. So for us to say the 14th Amendment is moot would be wrong completely, because first of all, you would need to repeal the 14th Amendment by the mandates of Article 5 of the Constitution. And also, it hasn't been adjudicated, and this issue of disqualification hasn't been brought up in a court of law to be adjudicated. So it's definitely not moot. Thank you for bringing that point up. So, I'm approaching an hour, and I'm going to log off now, and I appreciate every single one of you. I appreciate the questions I have received. I don't know if there are any more questions. If you have any more questions, please post them now. Let me see if I've missed anything. I haven't missed anything on this issue, but lastly, since 3 of you are still here, I just would quickly like to say that Fani Willis sent a letter to Jim Jordan that was just, it was just the biggest, it was big. And she effectively read in the riot act. and I was so thankful that Fani Willis just did not hold back. You know, Joyce Ellen said on X that, you know, no, sorry, MSNBC, I saw it on X, that, you know, it was understated, but it was pretty stingy, you know, effectively saying that, butt out of state prosecutions, you are violating the separation of powers doctrine, you are violating states' rights, you don't have jurisdiction over how a state attorney enforces state law. And, you know, Fani Willis will be more than happy to adjudicate this when the time arises, should Jim Jordan have the nerve to even go there, to bring it up and take it to court and want this information that Fani Willis has no duty to give to Jim Jordan and the House Judiciary Committee. Congress simply has no power. You know, the Judiciary Committee of Georgia's state Senate or House or Georgia legislator might have that power, but Congress, Jim Jordan sure doesn't have the power. And we recently heard Brian Kemp saying that he won't go along with a GOP legislature move to unseat Fani Willis. So that's not going to happen. Another quick note I wanted to tell you about was, hello, Veronica. You are new. I haven't seen you. Welcome. Another thing is, we got news that the grand jury about the January 6th insurrection reconvened in DC a couple of days ago. And the grand jury is scheduled to expire, it's scheduled to conclude in September. But depending on the investigation, Jack Smith can extend it. So that's where we are on, I mean, you know, the man is already 4 times indicted. And, you know, Senator Fetterman of Pennsylvania, you know, called Republicans on their bluff about impeachment inquiry of President Biden when Donald Trump has been indicted, criminally indicted, in 3 jurisdictions and 4 venues. So that's 2 cases in federal jurisdiction, 1 case in Georgia, and 1 case in New York. And we very well may see more cases. As I've said, the wire fraud case or case in connection to the Save America PAC and the money that Donald Trump raised by saying that he was going to investigate election fraud and then stuffed it into the Save America PAC and then paid all his loyalists with it and is paying legal fees with that money of his co-conspirators. Jack Smith is looking into that, and I wouldn't be surprised if that is a separate indictment. And, you know, I always have the wishful thinking that there will be enough evidence to link Donald Trump to the Friends of Stone group, to Roger Stone, to Michael Flynn, the Proud Boys and the Oath Keepers. But as we know, the seditious conspiracy charge has not been brought yet. And I believe that's because Jack Smith has not been able to find evidence and circumstantial evidence and strong circumstantial evidence to bring that charge. So thank you so much for being here, Art Garden, and thank you very much for the compliments. And I don't see any questions. I'm going to log off. So if you have just joined, if you came in the middle of the stream, you can go back and check out the topic that I'm talking about, which is disqualification of Donald Trump from running for elected office under Section 3 of the 14th Amendment. And this is going to be a continuing episode. This is part 2. I will do several more parts because the law review article is really good, and I implore you all to download it. It's in my description box of this video. So with that said, thank you so much, everybody. Take care.